Good
Look at
morning.
everybody.
Hi, everybody.
Here we go. Hello.
Morning.
Hello and welcome. Welcome, everybody. So glad you're able to join us today on this little webinar we like to call Virtual Brunch with Actual Nerds. My name is Leighton Rasco. I'm a nerd, and I'll be moderating our discussion today. This particular morning was a particularly great morning for you all to join us today because we have Jonathan T. Howe Esquire with us today. John has literally argued before the United States Supreme Court, but for some reason he has agreed to do this webinar. Before we formally introduce John and the rest of our nerds, I'm going to run through a few housekeeping notes. Please update your Zoom name to reflect your full name and your company name. You can separate it either by a dash or a bar. It's your choice. You may have noticed that you came in on mute today. We ask that you stay that way unless, of course, you want to be heard. And if that's the case, just unmute yourself. Because this is an Ask Me Anything style webinar, questions and further discussion are encouraged. We will be moderating, I'm sorry, I'm having trouble speaking today. We will be monitoring the chat as well as looking for virtual and physical hand raises. To raise your hand, or a virtual hand, look in the reactions tab. We have an archive. Our archive is growing at a steady pace of 1 every 2 weeks. And that is approximately the same pace as grass growing. But we hope that you'll find our recorded videos a little bit more entertaining. So check them out at attendingnet.com/archive. And we'll have this one up in a day or two. Now let's get on with the introductions. Presiding over this discussion is the Honorable Jeff Rasco. How are you doing, Jeff? Oh,
I left my robe in the closet, John. I'm sorry. But I'm so through. John and I go back, it's counted in decades, and I just couldn't be any more honored to have him with us today.
Thank you very much, Jeff. Great to be with you guys today. I thought when you invited me to do this program, it was to correct all the technological errors that Corbin had made in his presentation. But if you really brought me on for that, that was a gross mistake. Technology and I are not necessarily the best of friends. A number of years ago, I was doing a program, and all of a sudden, everything sort of went blank on the PowerPoint. And I made the comment, back when I started practicing law, the biggest technological challenge I had was making sure all 7 pieces of carbon paper faced the same direction. Somebody came up afterwards and said, Mr. Howe, I didn't want to embarrass myself, but what's carbon paper? We've made a lot of progress from those. Remember the old transparencies we'd put on the overhead projector and so on and so forth, or the multiple where you had the guy come in with his 52 slide presentations all put on the cameras and try to coordinate them, and it would become sort of a good contest. Well, what we're dealing with now with the virtual environment that we're living in has really changed a lot of things. We've had, go back a few years, and the comment was, well, we're going to have teleconferencing, that's going to replace live meetings. We sort of progressed from there. We learned from that lesson that it really didn't replace live meetings. There is still that desire on the part of the human being to have the ability to shake hands, toast, have a conversation with somebody, hopefully a little bit closer than 6 feet away. But that's the environment we're in today. I was doing this week, the American Bar Association had their annual meeting, and they had converted from a live meeting here in Chicago to a virtual meeting, and they learned a lot. And I learned a lot just watching it as a special advisor at the ABA and just looking at how some of the things were done and where the success factors were and where the success factors were not. The number one lesson is choosing your platform. Who is going to be your overall provider of that virtual meeting? Who's going to be responsible overall for doing it. ABA had a master agreement with one company, Freeman, who did a good job. Then they had a number of subs that were out there who were doing various aspects. ABA, when it has an annual meeting, has so many activities that go on. The ABA, we come into a town, we take over like about 400 meeting rooms for meetings and activities that go on a simultaneous basis. So it's a real difficult logistical thing to put on. When we do it virtually, it had its challenges, needless to say, as well. But we found that some of the platforms were very good, and some of the platforms were not. The biggest problem that was overall was with the ABA, and probably with many organizations out there where you have a continuing education requirement. Many of the state bar associations require that there become a verification factor, which means you sort of bleep on and say, yeah, I'm still watching the program and so on and so forth. Well, the one company that was been retained to do that fell flat on its face. It was a disaster overall, and it was too late then to get other people up to be able to do it. So look at your platforms, look at how you're going to do that. One of the other things I think we have found with a lot of clients is that when you go virtual or you go hybrid, the speaker availability becomes greatly enhanced because speakers don't have to necessarily travel. They can get in and get out within the period of time that they're allocated on the program. Yeah, some of them actually have the audacity to maintain their same price level for what they're doing, but again, you have to maintain what's important to the success of your program and your event. But just some observations from there. Leighton mentioned that this is pre-recorded. Obviously, when you pre-record something, that means that people, when they say something, are going to be part of that recording. So you want to make sure you have the consent from everybody to be recorded and participate in the overall program. I will go back to American Bar and say probably the best platform for most of the activities, without giving it a plug, but I just did by saying Zoom, which is the platform you're using here, where people do actually have the capacity of being able to see other people on the call. One of the interesting observations that was made, not only at the ABA meeting, but by several others, some people are reluctant to be live on camera because they may be still sitting there in their bathrobe or robe, as the case may be, Jeff, and looking Jeff, at it and trying to do it. So an alert up front is, yeah, you can always turn your video off, but you can still participate in the program. Helps increase the participation. One other observation, and this is personal to me, is that if you charge something for people to be able to participate in the program, you get a lot better participation rate. Now, this is sort of the exception here with Brunch with Nerds, because you come here because you hope you're going to get something beneficial out of it. It's nice to see the people that you've worked with over the years and know over the years. So I think those are things that come into play and how we look at it. Observations that have been made too is what's the ideal length of a program? Well, it ain't 8 hours a day, that's for sure. And what we have found is that with clients in our little surveys that I've done, is that the tolerance level is about 3 hours, and that you do have some kind of break in between, perhaps in that 3 hours, stand up, turn around, spin 15 minutes, or take a biological break, or whatever it might be. But those become sort of the factors that we're looking at. Where are we going future-wise? And this is a kind of call we get a lot, is what are my contracts going to look like? Well, your contracts, I do not believe in the new norm. There ain't no norm coming back. We're dealing with a new reality and how we're going to be dealing with things. And so a lot of what we're looking at now is the hybrid is probably going to be more and more the avenue that is followed in producing and presenting materials overall and conducting meetings and programs. And the hybrid requires some new consideration just entirely as to what you're looking at when you're contracting. We have our own little RFP requirements. Well, one of the major requirements you're not going to have is asking, what's your bandwidth? How much can you sustain in being able to present programs out there on the internet to those people who want to participate by hybrid. And so bandwidth is going to be a question, and then the cost of bandwidth as to what you're going to have is going to be a key element in your negotiations, and what the capacity is for the property or the venue to be able to deliver the requirements that you need to have in order to transmit electronically the content of your program. So a lot of just quick random thoughts that are there. And I think, Leighton, we got some questions, and Jeff, as you said, this is wide open. They don't all have to be on technology, please. They can be almost any area you want to go relative to the industry, where we're going, what some observations are. And remember, at this point, this is free legal advice. It's worth what you pay for it.
I just got to, I mean, you mentioned Zoom and being a great partner on ABA. You know, I've heard some, you know, pushback on Zoom because it's not secure. Is that so last March?
I think in no small part, Jeff, it is last March. One of the interesting things is I was on a Zoom call the other day with a major hotel group out of Las Vegas, and they're prohibited from utilizing Zoom for purposes of their medium because of concerns about security. And you look at that as to where that all comes into play. So, you know, you got to pick your platforms carefully and know what the limitations might be or what the resistance is with some of the players who are going to be on the call.
Do you remember what they settled on that was more secure than Zoom?
I'm sorry?
Do you remember what they settled on that was more secure than Zoom?
I don't. Not off the top. I assume they have an internal VPN or something of a similar nature that they would be using overall. But I mean, it's not. We're seeing that not only with properties in, let's say, Las Vegas. We're seeing that with corporate America, corporate Universal, as that there is still a bit of a concern. I think Zoom has done a lot to boost up their security. I'm not going to vouch for it because I couldn't if I had to. But I think what it looks at is you want something that's user friendly. And when you're doing a webinar, let's say like this, versus doing a corporate meeting to go through the latest technological developments that you're making to suddenly spring on the public, two different kinds of programs. So I think you look at it accordingly as to what is going to be acceptable, how you're going to go about doing it, and what is going to be the best communication device that you have. But looking at the platform, some have limitations as to what they may require. For example, some of them may require that you only access through Windows 10 or whatever it might be, or Windows 365. So you've got to look at what the platforms on that. This is where I would definitely yield to my good friend Corbin as to what's out there and what's acceptable, and probably can add a little bit more to this conversation than I can in that respect.
Well, Corbin was last week, so I'm just kidding. Corbin, please.
Corbin is always
please.
Next. Come on.
Corbin unmuted. Let him go.
Oh, you know, I think that I would agree with Jonathan that it is kind of last March where all those people have learned and they've tightened up their security issues, and I think it's fairly secure. There, you have Microsoft Meet. You have other platforms that are out there that are, you know, have had more experience in building secure platforms, but I don't see, unless you're, you know, covering military secrets or things like that. I think that it's Zoom seems pretty secure to me from what I've read.
Yeah, there are definitely different settings that you can explore to make it more secure or more open. But we have a lot of questions that we haven't got to, so I'm going to paraphrase some of these because a lot of them are kind of the same. Can you kind of give some guidance into what contract clauses you're going to see in the future as far as, like, you know, COVID and et cetera?
Well, obviously, one of the things you're going to be looking at is the so-called force majeure clause, which is always a favorite topic as we've going back to February of this year and how that has played out. And force majeure is a legal terminology. I always kiddingly say, beware of lawyers bearing Latin phrases, but force majeure is French, so I guess we have the opportunity to get into it. The deal here is that force majeure at the common law was based upon the concept that something happens which is not controlled by you or me or man, woman, or child that makes performance impossible. In other words, it's an act of God or something over which nobody has any control, and it makes that performance impossible. Well, having said that, we have now seen an expansion of so-called force majeure clauses to include a lot of things that might be controllable, but they're now included within the force majeure clause to excuse performance. And remember that for the most part, force majeure works both ways. Once in a while, we'll see somebody try to design a force majeure clause that only works one way. Ain't going to be the case overall, let's face it. So what I look at is the traditional force majeure, acts of God, hurricane, tornado, flood, whatever. And then what are the other things that will excuse performance without liability? And those might include a pandemic. The problem is, even with force majeure, if we say force majeure and we have the word pandemic in it, we got to go to the bottom of the clause. The force majeure has to have some kind of effect. And in most force majeure contracts, it says makes the performance impossible or illegal. Now, when we're dealing with COVID, maybe it's not impossible. The hotel may be still open, the convention center is open, the airplanes are flying, et cetera, but is it now made illegal? Well, let's say you have a regulation in effect or an executive order that says no meeting of more than 50 people at any given time. Well, that still may be possible overall. So we've got to be very careful on how those clauses are worded as to how we're going to be able to escape that liability. What we look at now, and I think the clauses of the future, are going to be more expansive, they're going to be more specific, and they're going to be more forgiving, if you will, as to what's going to fall within the perimeters of that particular clause, which will excuse performance. So looking at that, you want to look very carefully at how those clauses are designed. One of the things that we have seen, obviously, since February and March is the postponement of meetings and a new set of dates being put into play. And one of the key concerns we have is, okay, you've got those dates changed. Have you changed anything relating to what the force majeure might look like at the time that meeting is to take place? Another thing that we really encourage you to do, right after you have who the parties are to the agreement, that very first sentence that goes across the top of the contract, you want to have a little provision is, what's the purpose of the meeting? What is going to make that meeting successful? How is that meeting going to be carried forward? What are the things that are element to success that you have to have? And then if we look at that and we have any one of those purposes is frustrated, we have another legal doctrine that comes into play, frustration of purpose. If there's a frustration of purpose, it allows us to escape from performance and liability. A lot of you probably have heard the terms commercial impracticability. What the devil is commercial impracticability? Well, it basically is premised on the concept that at the time you entered into the contract, there were certain commercial factors that came into play that were key to the elements of performance. And something happens in the future which is totally unforeseen. Notice the word unforeseen. Unforeseen, unknown takes place, which interrupts the ability to perform commercially the outcome of that program. And it can be made financially impossible, it can be made financially undesirable, whatever. But the key element is it's unforeseen. Well, right now, folks, we know that a communicable disease, whatever it might be called, is something that can happen. So does that provide for commercial impracticability? Maybe not. So what we do is now we list as to those things which are going to excuse performance, so that we have said, even though this may have been foreseeable, if it has an impact on causing us not to be able to deliver a successful event, then under those circumstances, it will excuse my performance and I'll get my refunds back and whatever. So contract clauses now are going to be extremely important. One of the other things too is going to be, obviously with all the executive orders and regulations that are out there, what requirements are we placing on the property or on the venue, and whether are placed on you if you're providing the program, to be in compliance with the law, the regulations, the executive orders. And so does that become part of the contract? And then does that then, if that cannot be done, make the meeting impossible or illegal under the certain? Maybe it does, but we're going to have to look at this on an individual basis. So a lot of these things that we're talking about here are going to be dealt with in the future, unknown, but will have an impact. So how do we provide for coverage to protect ourselves? One of the other things too, many of you know I have been a crusader for a lot of years against the concept of win-win negotiation. It's a lie. It doesn't exist. It was designed by a child psychologist who wrote a book on how parent and child should relate to each other and said it should be a win-win situation. And obviously a guy who did not have kids. What we want to look at here is a situation in which it's a partnership where we share in risk and reward. And over the years, obviously this is a relationship business. The problem we have right now, the people we have that relationship with may no longer be where we were doing business. They've been laid off, they've been furloughed and gone. And that has been a major problem that we've experienced over the last 4 or 5 months of finding who's in charge now, who knows who the heck we are, what we bring to the table, et cetera, on both sides. Because we've seen a lot of meeting professionals laid off, whether they be supplier or vendor, or on the organizational sides. So I think a lot of challenges out there. That's a very long answer.
Have you seen any of these actually go to court or have some resolution between a planner and a venue?
I'm not seeing any, and correct me if anybody knows of anything to the contrary, we've not seen any where it has gone to court per se on somebody alleging force majeure and the other side saying, no, it's not a force majeure, with one exception. When we're dealing with insurance companies and where people have filed lawsuits basically getting declaratory judgments as to whether there is coverage or there is not coverage. Here in Chicago, about 3 days ago, major lawsuit was filed on behalf of 41 restaurants and venues against a series of insurance companies that basically have denied coverage on business interruption, not convention disruption or convention cancellation, but just on basic commercial liability insurance and where there is a business interruption provision that might be in it. And we're dealing with everything from communicable disease, exclusions, et cetera, et cetera. So the insurance area right now is the one that is where the major litigation is going forward. Have we heard threats of going to litigation? Of course. Remember, the courthouse is open 5 days a week, generally from 9 to 5. And, you know, if you got the filing fee, you can file a lawsuit. It doesn't mean you're going to win, but the problem in this environment today is the cost of defense of a lawsuit is where the major impediment is relative to where we're going now. So we're looking at, I think in most of the situations we've had, and I don't know how many, we've been doing a lot of this 24/7, and about 99.9% of the situations we're able to reach a settlement or an understanding or something that goes forward. My real concern is as we reach those settlements and understandings and going forward is we don't put ourselves into a worse predicament than we would have been had we not done it or gone forward with it. You know, with force majeure in a lot of these situations, my crystal ball is very foggy. My Ouija board has refused to work, so I cannot predict anymore what's going to happen in the next hour than I can predict what's going to happen 6 months from now.
Yeah, I believe Ouija boards, you need more than one person, which is not social distancing. So I'm glad that that's not working for you. So that's mainly like planner to venue, but what about the actual participants? Like, what verbiage do we need to put in waivers on registration forms, and would they hold up in court?
Well, a lot of controversy, a lot of discussion, Leighton, that's taken place on the effectiveness of waivers. In other words, somebody, not necessarily a waiver, but assumption of risk. And waiver basically says, I won't sue you. Assumption of risk says, I will assume the risk of participating in your program if I go forward. Now, I participated for a large number of years in bundling myself extremely warmly, putting my feet into a pair of vices, attaching them to long, narrow boards, going out, putting my fanny in a steel basket suspended to a wire, and going to the top of the hill. And the first time I think I got on a ski lift and went to the top of the hill, the sign said, prepare to meet thy Lord. And it really said, prepare to unload. But the key element is when I bought my lift ticket, there was a little sign over the kiosk and a little something on the back of the ticket that says, hey, Bunky, skiing can be dangerous. You may run into a tree may run into you, somebody may run into you, you may fall down, you may break bones, you might even die. Have a nice day. And did I assume all that liability? Well, to some extent I did. I assumed that there was liability in skiing. And but I did not assume that if I'm coming down having a wonderful run and I make a left turn and a right turn and suddenly now I'm 80 feet in the air because I went off the ski lift, but it wasn't marked. Is there some liability there for them not marking? I did not assume the risk of the ski slope not properly marking. All right, long answer, here we go. When we're dealing with the waivers or the assumptions of risk on this, remember Trump with his rally, he had, if you're coming to the rally, you're going to assume that you might get sick from COVID. We're seeing a lot of that. You go to Disney World, you go to any public place these days, there is some kind of assumption of risk. Whether that will be upheld by the courts depends on how extensive the risk was described as to what you might be encountering, number one. Number two, the jurisdictions all over the world will vary on the effectiveness of that assumption of risk. Number three would be if it's a minor, somebody under the age of 18, the parent may sign off on it, assume the risk on behalf of the kid, but in a lot of states, in a lot of jurisdictions, when that child turns 18, they can disavow what mom or dad or the guardian did for them and still come back and file a lawsuit. Now, in the COVID situation, we also have the burden of proof. I got to prove that by virtue of going to your meeting, I came down with COVID-19. I came down with coronavirus. That may be a little bit difficult. Remember, when we go to a program, let's go through the entire journey. I leave the house, I get into a car, I get into a cab, I get into an Uber, I proceed to, let's say, the airport. I then check my bag, go to the ticket counter, go through TSA, stop to buy a newspaper or a pop or a cup of coffee at Starbucks on my way to the gate. I get to the gate, I get on the plane, I'm sitting next to somebody who's sneezing like mad, whatever it might be. How do I establish that by virtue of being at the meeting, I am now going to be able to sue the meeting sponsor for the liability? But let me shift that a little bit. Let's say you're an organization and you require the person in your employ to go to that meeting. I have now basically, by making that requirement in a lot of states, taken on the liability regardless of that, because I put them on the journey. Anywhere along the way on that journey, I'm probably going to be eligible not to sue, but to file a workers' compensation claim or a disability claim based upon that. So the laws vary. It's all over the place. And this is one where you need to check on every incident as to what's going to be. Would I suggest you do a waiver? Sure. Have somebody sign that assumption of risk. Have that as part of your registration materials. Tell them up front what they're going to be expected to do. And by virtue of signing up for the program, they've assumed this risk. And this is one that's been pretty interesting over the years. We have, for example, you go onto a website and all of a sudden you have this little thing. You agree to the terms and conditions of this. Well, the courts now are saying you can agree to the terms and conditions, but before I agree to the terms and conditions, I got to see them. And in so many situations, what you do is you hyperlink the person off to another page to look at the terms and conditions. Now, my recommendation is before they get to that I accept, they go through the 19 or 20 pages of the terms and conditions before they get to that I accept provision in the box. So that at least you can show that the person did scan them. They didn't read them, that's their problem, but they did have the opportunity to see them without having to go somewhere else before they hit the I accept.
That's good advice. It's you know, I always just scroll right through those things. So I'm the person you're talking about, I guess. The next set of questions kind of revolve around relationships between the planners and the venues. You know, I think they're both gonna have to give a little to make it work again, because you know the planners are looking for a way out, the venues want to protect themselves as well, but you know, where are they going to meet in the middle, and how is that going to work out?
Well, back to the fact that it's a partnership. When you're in a partnership, you're sharing risk and you're sharing reward. Well, lately we've been sharing a lot more risk than we have been in reward, and so that is how far can you go. Part of the problem now too, let's face it, if I'm a hotel or I'm a venue, I live and die by cash flow, and now my cash flow is almost non-existent, and I now have that friendly lender who extended me all that money based upon my business plan that I developed in 2019 when things were really super glorious, sort of breathing down my back saying, you got some payments due here coming in the next several months. How long am I going to be around to even provide the services in the future? So what we're looking at here is how do we have the survival mode for both, because we're going to need them as we go forward. The difficulty here is trying to reach that middle ground as to what's going to work on both sides. That's why we see so many agreements to reposition the program to a later date or to work out some other kind of arrangement where there is some protection or at least some hopeful assurance that something will happen positively in the future. But I think the real issue now is, you know, remember back in February, people were projecting that come September, businesses would be back to semi-normal, that we would be meeting and so on. Then it went to March, then it was extended out to, we've just seen a progression of pushing the dates out. And then when you look at some of the things, there was just a projection the other day as to when the airlines might have some sense of recovery, it was 2024. And so here we are in 2020. And we're now looking at 4 years, 5 years perhaps, before certain very vital elements of the area that we work in are not going to be ready to help us. And we've seen that Virgin Atlantic just declared bankruptcy. They just went down yesterday. We've seen a lot of hotel chains that are going in. IHG was just challenged on one of their major users of the program and their res system saying, hey, you owe us money, and if you don't pay us the money, we're going to just drop IHG as our brand. And so you have it on both sides as to how this is playing out, and everybody's scrambling to protect their flank. The difficulty is how much tolerance there is on both sides, and how you can work something. We're doing a lot of cutting and pasting, trying to go forward. There is no real easy answer to this overall, and I think the deal is how do we work in the best way to try to provide some semblance of order and some protection. Now, a lot of associations and corporations were smart and bought cancellation insurance or business interruption insurance before this all hit January 15. Those that were bought after January 15, obviously, you have the communicable disease exemption. Prior to that, we've collected on behalf of clients quite a, in the millions of dollars on cancellation insurance and business interruption insurance that were signed, late last year or within the first 2 weeks of January of this year. Those that were after that are sort of SOL, if you will, and not going to be able to collect. And now, let's face it, you're not going to be able to buy any kind of insurance policy going forward within a reasonable premium to provide for that business interruption. So how do we shift the risk? We now shift the risk by putting it in our contracts. Remember, look at a contract. A lot of you know my definition of a contract. Pretty simple. A contract is a self-inflicted wound, but for the existence of the contract, no rights, no responsibility. So what we're looking at is how do we use that self-inflicted wound to protect ourselves from liability that we might have otherwise been able to insure.
You know, one thing that that occurs to me in this, when we're talking about the sort of relationships between, you know, the I hate to call them two sides because they're the two partners in all of this, but you know, one of the things that makes it different is everybody's impacted this, you know, from the pandemic, and so it seems like people are trying a little bit harder to reach those compromises and postpone those meetings rather than force cancellation fees and all. But I mean, we've heard of people, you know, that need to cancel because their attendees can't get there, but we've also heard of venues who have needed to cancel because they can't get the workers there. You know, so it's on everybody this time.
Yeah, and you're right, Jeff. I mean, part of the difficulty now is you've laid off those housekeepers, you've laid off those restaurant staff, you've laid off, you know, a lot of your middle management who provide the basic resources to make it work. I just saw a recent article about where am I going to find my CSM, my convention services people, because they're gone. And we have a lot of people who take an early retirement, whether desired or forced. They've done it and they're not coming back. You've got sort of the economy playing against them. A lot of controversy over whether unemployment compensation is a bonus or a negative. But if it's keeping people from coming back to work because they're making more money by not working, you know, obviously it's a negative. So the key element here that we look at is how do we get people back to work? And I think one of the things too, we talk about hybrid. Think of a hybrid meeting as being twice the work, because you've got to do the live event and you've got to do the virtual event. And so if you were just doing the virtual event, that's one activity. If you're doing the live event, it's one activity. When you do the two, you now take on twice the workload and twice the concern that you may have, and how you work that through is going to be a key element to being success as we go forward. And I dare say the one thing my crystal ball may allow me to look at a little bit is, you know, we're going to see hybrid. We're going to see hybrid going forward. How long, I don't know, but we're going to see hybrid, and it's going to be a part and parcel of the success factor, because now if I'm doing a hybrid, how do I monetize that hybrid? A lot of the hybrids or a lot of the virtuals have been given away, and sort of like the small business operator and independent planner who's been giving it away and living on commissions. When you now got to prove what's the value of participating. If you're giving it away, the perceived value is it's worth what you pay for it. So I look at this as being a real issue as to redesigning or reevaluating business models at all aspects of how you're going to play the game.
Thanks. Megan Rame asked a good question. What's the liability for like attendees, exhibitors, conference centers, planners, etc., to inform event hosts if there's an outbreak of COVID after the event?
Well, one thing I think one thing we're seeing is you may not disclose it, but it's going to be disclosed out there. There's now a lot with the contact follow through and requirements that if somebody comes down with it, they've got to make information available to who they've come in contact with. You have states and cities which have set up people who will pick up the phone, and if you check into a hospital or you check in with a doctor, what mandatory requirements are them for disclose. We see daily reports from states and communities as to how many new cases there are, and then the contact portfolios become a very important factor in prevention. So I would say that just from the standpoint of, is there a requirement that you disclose to somebody that somebody came down with COVID at your program? I would say you probably want to, and you want to do it, and then you might want to say, if you were at this cocktail party or whatever. Balance that, however, with the rights of privacy and what privacy rights are invoked by the person who has come down. In a lot of situations, I've known this with people who discuss this with me, that they have been contacted by a friend who they may have been at a program with or had met somewhere along the line, saying, hey, you may want to go out and get checked because I just tested positive. So I think it's going to be one of those deals where it's going to be semi-required. And if I'm the event sponsor, I think in good citizenship and the rest, I'm going to disclose it, that somebody did come in and was at that person. I'm not going to identify the individual per se, but I'm going to say it was at the cocktail party if you were at this or that, or if you were at this program or that program. There's a possibility you may have come in contact with somebody who was involved. In our own office building on my floor, where our office is, this is back in March, we received notice from the building that one of the individuals at one of the tenants had come down positively with COVID-19. And they just made the disclosure with no recommendations, but they just made the disclosure.
So what about in the future? Like if they have a vaccine, would it be legally acceptable to require somebody to sign off and say, yeah, I've had the vaccine before they come to your?
We have seen the controversy that's involved with people mandatory vaccines for your kid to go to school, and the lawsuits that have emanated from that kind of requirement. The one issue with the vaccine, there are a lot of issues with the vaccine. Number one, you're going to get a lot of people who go out and get vaccinated. Is there going to be enough vaccinations available to people to be able to do it? We know that we lose 30,000 to 50,000 people a year to the flu. Duh, don't we have a flu vaccine every year that's out there? And how many people actually do it? Even though technically that flu vaccine now is available at no charge to people, but they still don't do it. They don't want to even have their kids inoculated for smallpox or mumps or whatever it might be. So I think that the issue of the vaccine, it is a trigger for some areas, like the state of Illinois says they'll reach stage 5 when there's a vaccine available. Well, that doesn't necessarily help me a whole lot. Yeah, the vaccine's available, but I don't know if people have got it. I don't even know if I can get it. And so how are we going to be looking at this? So I think the issue of vaccine is maybe a little bit of a Trojan horse that we want to be careful about. You know, obviously I want to stand in line if that vaccine comes out, just for my own sake. And I'm sure as hell going to hope a whole lot of other people do too, that I come in contact with. And then what are the efficacies of the vaccine? How successful is it, et cetera, et cetera. Lots of questions. You know, some of us go back, you know, early on, remembering the polio epidemics in the early 50s as to what was there. And there was never until Salk came along and Sabin came along with a vaccine, moms and dads and kids were scared to hell as to coming in contact with polio. And so then, you know, people got the vaccine and pretty much got eradicated for the most part, but we still see flare-ups of polio in other parts of the world. And then that also becomes a question. We're a lot more mobile today than we ever were in the past. And so a person can be in South Africa on Sunday and be in New York on Monday.
Yeah, I listened to a really interesting podcast about a polio vaccine the other day, but I won't get into it right now. It was a Stuff You Should Know. If you don't listen to Stuff You Should Know podcast, you should, because it's awesome. Karen Fogle, you say latest polls are showing 54% of US say they won't vaccinate event when one is available. Are you just saying that like 54% of people won't get vaccinated if one's available, or is it event specific?
Yeah, she just put a T on the end of it, even.
Yeah, I meant even. Yeah, I didn't mean event. Sorry. autocorrected for me, or my mind autocorrected to the wrong thing. Who knows?
You probably write event too much. And
Yeah,
Thanks,
that's
Karen.
true. Good catch.
No, again, it's, you can bring the horse to water, but you can't force him to drink.
Mhm. Yeah, and the sad thing about it is, even just a few weeks ago, like 2 or 3, it was a better percentage of people willing to get vaccinated. And that's dropping all the time for some reason, which kind of doesn't make sense with the fact that we have major outbreaks and hospitalizations. But it's always perception, for people and what they believe. So that's not only a problem, but the other issue, and this almost is a polio issue and not being able to eradicate it completely, is the fact that you have to have a really high percentage of your population to vaccinate before you actually get a really good benefit. And that's why 102 years later, we're still fighting the dang flu in spite of the fact we have vaccines. So we have too high percentage people who won't vaccinate, afraid of it or whatever. So
There's going to be a lot of watchful waiting, I think, as to what people do and what they're going to become acclimated to. I dare say there are a lot of people who are ready to spring out and grab anything and run and think that they're immune now. So it's going to be a lot of does the vaccine really work? And back to the flu vaccine efficacy is generally only about 70% of the potential for being able to cover people. But there you go. Lynn is waving her hand.
are you just saying hi?
Yeah, you want to unmute with a question, Lynn?
I unmuted her and she muted herself back. I'm sorry. You're still muted.
Well, I think what we're seeing basically is that human nature being human nature and totally unpredictable, we're going to have to wait and see what plays out here over the next several months and years, really, as we look at this.
Yeah, there's a lot of questions around the vaccine, and that's not exactly why we have John here, because he is not a infectious disease scientist. He is an attorney. Maybe we can get one of those in the future. I'll reach out to Anthony Fauci, but we'll see if
he'd be a good nerd. He would be a great special guest nerd. You work on that, lady.
They look alike.
So, other questions from the attendee, from everybody that's joined? Anybody else have something they haven't seen on the chat get answered, or?
I'd like to raise one, or just ask a question of John, and that is, can you talk a little bit about the third-party independent meeting management company, especially those who work on at least part of their compensation comes from commission? The importance of the relationship, the contractual relationship between the third-party company and the client with regard to the commission issue.
Thank you, Rod. I mean, this is a subject near and dear to both Rod and myself, as we've discussed this over the years, and Jeff as well. MPI, you may know, has a community called the Independent and Small Business Owner, which, if you're not a member of MPI or not a part of and you are, but you're not a part of that community, you ought to think about it. The key element here is that the third party with commission, that with meetings being canceled or delayed or postponed, what has that done to the whole commission structure that a person might have? I've been with Rod, we have been preaching for a lot of years, is that if you're telling the people that you're getting the service for free, how do we come back now and say, golly gee, this service has a value that I want you to pay for? And so again, looking at what the particular business model might be becomes so key, is that you want to show people that your services have a value and that that value is X, but you will use the commission perhaps to offset what that value is or what that cost would be. And to the extent that there is not a part of that which is recoverable by commission, it'll be paid by the client. Simple. The other thing, and one of my little watchwords here is, if you're in this independent small business owner segment, and a lot of people have now suddenly become part of it because they've been laid off or are looking for something else to help them get over the hump, you got to ask yourself the question, are you a business person in the meetings profession, or are you a meetings professional in business? Hopefully it's the former. You want to look at this as being business. And when you're running a business, you have a whole different attitude as to what you're looking at and how you do that. And so I think the value proposition of that third party has become even more important. I might add that Jeff and Rod was my co-chair for a long time with the ISPO section when we started it. Jeff is a member of the advisory board, but the element here is, I think a lot of you I know on this presentation are all third party independent, but you work on a different format. Take Corbin, he's an independent business person who does not live on commission, he lives on fee, as many of us do, but those who have gotten used to the commission opportunity with the 10%, now the 7%, soon to probably be 0%, need to really reevaluate exactly how they're doing business.
All right, well, we are running up against the time limits, so if anybody has a quick question for John, please unmute yourself and just say it. If not, I'm going to start.
John, would you go into that a little bit more about that purpose clause that you mentioned? I really find that something important to add that we haven't to all the other clauses.
I would say that becomes a very second clause in your contract, is what's the purpose of the meeting? What is it you're trying to achieve? What is going to make that event successful? And if any part of that is not going to be present for whatever reason, the purpose of the meeting has become frustrated. So if it's absolutely imperative that at least 250 people be able to be at the meeting, and you can't get 250 people, your purpose has been frustrated. If it's important for you to have Colin Powell speak at your program, and Colin Powell can't show up, or any, along that line, the frustration of purpose is there, and that may give you an escape clause to get out of performance or limit your liability overall. But I think it's important, and this is something we basically say, this is going to be the XYZ Association program, or the corporate meeting of all our salespeople. But you don't, you say who's going to be there or what it is, but you don't say why it's there. And somebody says, we need to have a meeting. Well, generally, isn't your next question is, why do you want to have this meeting? What is it you're trying to do? What is it that's going to make this meeting successful? Because that helps steer you as to what kind of venue you want, what kind of environment you want to put the program into, what are the keys and the elements of success, and that's what we want to judge this on. So the bottom line question is, we don't do this, we haven't done this, but let me urge you to start doing this as a very second thing. Back, we used to have the old whereas clauses. In my office, I always said grounds for immediate termination is the word whereas or heretofore are part of the first part. We want to write contracts so people understand them. But I think the element here is, let's set forth what it is we're trying to achieve by purposes of holding this particular activity.
Well, thanks, John. This is a good question, though, so I don't want to cut it off. Carolyn Davis, a virtual meeting, do we need liability insurance in addition to E and O?
Sure. Bottom line, yes, you need liability insurance, because you may get some speaker who goes totally off on a tangent, or you may have something that happens, or somebody's privacy gets invaded, or you get hacked, or we could list the horribles
That sounds like
and
E&O.
go on and on and on. But just doing business today, you want to share the risk, and the way we share the risk is buying insurance. And the whole concept of insurance is risk sharing and spreading it across a whole bunch of people besides yourself, and for which you pay a premium. And then the question becomes what's covered. The key element here is getting yourself a good insurance broker who understands what you do. I oftentimes, and some of you have heard me do this, when doing a program with meeting professionals, one of the questions I like to ask is, does your mother really know what you do for a living? And that becomes sort of the same thing. Does your insurance broker know what you do for a living?
Right. My insurance broker does. But my question is, E&O covers a lot of the things you just mentioned. So do we need liability insurance in addition to E&O?
Well,
that speaker is E&O.
Yeah. Directors and officers liability or professional liability is one thing. Comprehensive general liability is a whole bunch of other things. D&O is for judgment mistakes and things of that nature. General liability is basically negligence, or where somebody is suffering an injury or a loss as a result of something you do or you don't do. Comprehensive general liability, you want to have that all along the way, regardless of what kind of business you're in. And one thing too, just from an individual basis, coverage that you may want to consider because it's important is umbrella coverage. In other words, it takes you beyond the coverage that you have and says, if you get up to the, let's say, $500,000 limit on your automobile insurance, this will cover you up to $1 million or $2 million beyond that, provide you with some extra protection. And the umbrella is exactly that. It's something over your head to help you, again, spread the risk. And umbrella insurance is not that expensive.
Thank you.
Yeah, that's great advice. And
duplicative then.
Well, it's not duplicative. It tags in, Jill, on top. It's sort of, it's another layer of protection. And so if you get sued for $1 million, your automobile insurer says, we'll take you to $500,000, but after that, monkey, you're on your own. This takes you on your own beyond that. And when we buy, well, not to get too involved in this, when you buy a commercial liability policy beyond the norm with Lloyd's of London, let's say, you have layers of insurance as all the people who are involved. It may not just be one underwriter. It may be several underwriters who agree to take certain segments. When you go to somebody and they say, we're self-insured, that means they have no insurance. And self-insured means they're going to cover it. But what most people do with self-insurance is they buy an attachment point. They say, okay, I'll self-insure for $1 million. I'll cover $1 million of my risk, but I'm going to go out and buy insurance should I get sued for anything above $1 million or have claims above $1 million. I've got this layering it, and it checks in when you reach that $1 million mark or whatever it might be.
Well, this is great. We have so many questions coming in right at the end that we can't answer them all. So let's try to get those in earlier next time, guys.
We may have to send out a Q&A.
Yeah.
Well, I'll be happy to look at them, Leighton, and but just I don't know. I don't know if you got it up here, but if you want to contact me by email, let me give you my email address. It's jth at excuse me, at Howe Hutton, HOWEHUTTON.com, one word, all lowercase. JTH at HoweHutton.com, and Jeff has just posted it in the chat room.
Great. Thank you, John, for joining us today. Everybody, let's
Thank you. Stay well, stay
clap
safe,
our hands
and
together
most
for him.
importantly, stay sane.
So thanks, everyone. Don't forget to mark your calendars for the next couple of brunches. We have what we're going to call lessons learned from the front lines. It's going to be some nerd on nerd action. It's just going to be us, and we're going to be talking about the things we've done. We've done a live event, we've done some virtual events, and we've been taking notes. So we're going to do that. And then on September 3rd, we're going to have Jim Spellos, also known as the Nowist, He is a renowned speaker, and you should probably join us for that one too. So we'll see you then. Thanks for joining us.